Clyde Muchmore for the petitioners. With me at council table are Melanie Regani and Paige Masters. The Oklahoma legislature had the entire legislative session this year to deal with a situation where they were hundreds of millions of dollars short of revenue to meet the expenditures that had been agreed upon. Nevertheless, it was the last week, in fact, the last 2 days before the end of the session, before they raised the several bills they did to try to take care of that situation. One of them being House Bill 2433, which is before the court in this case. It imposed, it imposed a 1.25% sales tax for the first time on the sale of all new automobiles. The Oklahoma Constitution, as amended in 1992, required that for all bills raising revenue, that they be passed more than 5 days before the end of the session, that they be submitted to a vote of the people, and if not submitted to the vote of the people, that they be approved by a supermajority, and that they be passed without the emergency clause, which would prevent a referendum by the people. This bill was passed not figuratively, but literally at the 11th hour, obviously not within 5 days. It was passed with a bare majority in both houses, and to prevent the referendum, it was also passed with an emergency clause to take effect July 1st of this year. Before the court this morning is the question as to whether creative lawyering, as the proponents of the bill referred to what they did, can be allowed to, in effect, if carried to the logical further steps that it would be, to, in effect, nullify the vote of the people that passed 1992. The respondent here argues in their words that this, and words suggested by the federal cases, that this bill be given this legislative or this constitutional enactment be given the narrowest possible construction. I want to start by observing that that is not what this court has held in looking at specifically at this constitutional amendment. This amendment created a new day. Prior to the amendment, the constitutional amendment, the only requirement was that the bill originated in the House and that it be passed more than 5 days. This amendment now gave it true meaning, because substantively now it needs to be either submitted to a vote of the people or passed by a supermajority.
This court's already ruled on that issue, haven't we? Whether it's substantive or procedural?
I'm sorry, whether...
Hasn't this court already ruled in a couple of cases, Calvi versus Daxon, for example, that it was a procedural change and not a substantive change?
It was a change in procedure, that's right. To say substantively, I guess I should have said meaningfully, it needs to be submitted to a vote of the people or a supermajority. That is a procedural change in how it be passed. I agree with that. But the court said in petition 348, which approved the ballot title and submitted it to the people, that it was to be given liberal construction, and that the power, that it was represented the power reserved to the people, that the people could delegate as much or as little of that power as they wished to the legislature, and that the power of the people was not to be crippled, avoided, or denied by technical construction. In the other case, in the most recent case in 2014, Fent versus Fallon, in which the court looked at the same amendment and gave guidance, I think, to how it should be interpreted in that case and in the future. And in that case, they said that the bill should not be subject to parsing by lawyers, but for the instruction of the people and the representatives of the government so that they can understand their rights and duties.
Well, Mr. Muchmore, we said that with respect to a question that was previously unanswered by our case law, whether the term revenue bill encompassed bills that decrease revenue instead of increase. But we specifically said in Fent v. Fallon that the well-understood meaning of revenue bill, as defined by 100 years of our cases, that meaning still held to the term, despite the 1992 amendment. And part of that meaning is derived from the leverage case. And I want you to address that specifically, because in leverage, we held that modification or removal of an exemption from the motor vehicle excise tax is not a levy of a tax, but rather it's a granting of an exemption from an already levied tax. So my question to you is, to side with you, do we have to overrule leverage, or is there a way to distinguish that case?
Certainly not. Leverage does not hold broadly that the withdrawing of any exemption is capable without further examination. Leverage was limited and spoke of the exemption that it had before it at the time, which was not, there was no exemption that was eliminated in leverage. What leverage did was before leverage, automobiles, new sales of automobiles were not exempt. Before leverage, sales of used cars were exempt. After leverage, it was the same. What leverage did was to hold that the definition of a used car and a definition of a new car would be clarified. The purpose of that, as I'm sure the court is well aware, was that new car dealers had been, on paper, transferring their car titles to other states and then getting them back and selling them at used. Leverage was aimed at specifically that situation, and it took care of it by defining a new car as anything of that vintage. What that meant was that revenue would be increased. But as leverage stated, and as the court has stated repeatedly, and said in Fent versus Fallon, and said in Anderson that first took this up, that revenue bills to raise revenues were not those by which revenue may incidentally arise. In other words, it came back to the purpose of the bill. And the purpose of the bill in that was to define what a new car was, to prevent car dealers from gaming the system for an exemption they weren't entitled, and that revenue incidentally rose.
But that's not quite right. I mean, in leverage, we were very explicit that we were deciding that case at prong 2. We were deciding it on the basis that on the four corners of the bill, it didn't levy a tax, because what it did rather was modify an exemption from a tax. We were very clear. We were not saying that the purpose of that bill was not to raise revenue. I think that seemed to be acknowledged. That's why you eliminate a tax loophole, is you want to get that revenue that you're missing out on. We said we were deciding it on the basis that that's not a levy of a tax in the strict sense. So how do you respond to that?
I think the court's cases, leverage and the others, make it clear that it is the purpose of the bill that counts, and they've looked at bill titles like this one that says it's an act relating to revenue and taxation. They've looked at others. In leverage, it was the Motor Vehicle Act and had to do with the licensing and taxes to be paid on motor vehicles. And the court has clearly said through the years that it is the purpose of the bill and not whether it incidentally raises revenue. There are a lot of things that go into looking at purpose, but the court has looked at the ballot title, they've looked at the amount involved, and they've looked at whether the bill really applies to more or less a special kind of situation, which it did in leverage. In Fent versus Fallon, the court looked broadly at this issue, and it said, it talked about amendments. It talked about, it held that a law was not proper if it directly or indirectly was for the purpose of raising revenue. And the court held specifically that nothing in the ballot title or text of the provision reveals any intent to restrict the legislatures from amending the existing revenue measures, which is what, of course, what they did here by amending the exemption, so long as such statutory amendments do not raise or increase the tax burden. The message of Fallon is clear, that you're not to parse it, it's not for lawyering, it's not for nice construction, it's to carry out the intent of the people, which it said was exemplified when they said that no new taxes without a vote of the people. And given that purpose, they did, even though they ultimately said this doesn't raise in the sense of increased revenue, they talked about the bill, and it was pretty prescient, as was the original, on what was to come, when they said that you can amend it, but not if it's to increase revenue, that we look at the title of the bill, here a bill relating to revenue and taxation, and we look to the purpose of the bill as to whether it is simply and nothing more than raising revenue.
Well,
Mr. Muchmore, if I may, Justice, let's talk about 2433 specifically. You've got a 3.25% excise tax, and you've got a partial removal of the sales tax exemption on the motor vehicle of 1.25%. Total them together, and it's 4.5%, which happens to be what the total sales tax is in Oklahoma, right?
That's correct.
Sales tax and excise tax, the sales tax is collected at the retail, at the merchant collects that sales tax. That's not in this particular bill, is it?
No, this bill treats the sales tax like an excise tax. If the legislature had simply said, we're going to raise the excise tax here, although the respondent has never acknowledged this, surely that would be purely and simply nothing more than a raise in tax, and it would be, whatever excuse was given, it would be prohibited by the Constitution.
And if the legislature raised that excise tax 1.25%, it would take 75% under Section 33. But if they also waive the exemption, if you follow leverage to its letter, if they drop the exemption on motor vehicles and sales tax, it would be 4.5% also. But it would only take 51%. Is that right?
Well, if that's the way if you read leverage as commanding that, but I think that leverage was specific to its situation, that it very clearly said that we're not talking about things that incidentally raise revenue, and it said as to what was before it at that time, which was simply a modification of the definition of new car, that such a bill is not prohibited, even if it incidentally raises revenue.
But
it depends what you mean.
You're describing leverage as sort of a one-off, and it seems to me that leverage is actually consistent with a policy that I think is articulated in our Constitution. I mean, if you look at our Constitution as a whole, you have Article 5, Section 50, which expressly forbids the legislature from granting exemptions from taxation. You have Article 10, Section 6, which gives the legislature the power to remove exemptions. You have Article 10, Section 5, which is basically a special laws provisions particular to taxes that say that taxes shall operate uniformly. When I read the Constitution as a whole, what I see is two things. One is that exemptions are treated distinct from the levy of taxes, and two, that we have a constitutional policy strongly disfavoring exemptions from taxes. So it's difficult to read Article 5, Section 33 as simultaneously making it difficult to get rid of those disfavored things. How do you respond to that?
Well, I don't know that exemptions are disfavored. The Oklahoma Tax Commission has added up all the exemptions and deductions and the like and said they come to $10 billion. And of course, by the arguments that we've heard here, anything that removes those is not increasing a tax, raising tax revenue. But whatever the attitude was prior to the case, prior to the amendment being passed, the court was very clear that the lawyers were not to find a way around it, and that whatever powers of the legislature had, whatever rights they had on exemptions, this bill brought this constitutional amendment, brought back to the people their reserved powers to say not what the legislature could do, but in this case, procedurally, how they needed to do it. To say what's favored or disfavored doesn't answer the question as to whether this constitutional amendment, layered over all of that, says that the legislature can do all these things. They may be favored, they may not be, but this power, where it raises revenue, is a reserved power that the people, right, for better or for worse, have gone into and have said that before the legislature exercises these prerogatives, it needs to follow these procedures.
But this is a two-pronged test. It's an and. It's raising revenue and levy a tax. I don't think anybody, I think all of the briefs conceded that raising revenue is not really a disputed fact, but levying a tax is. An exemption is different from a tax. You don't agree with that?
Well, certainly an exemption is different from a tax, but this bill had the practical effect, directly or indirectly, of levying a tax that hadn't been there before and imposing a duty to pay that tax. I think that's what this court was saying in Fenn versus Fallon, that you look at what it does.
You talk about equalization, and until about the 1980s, I think, the excise tax and the state sales tax were identical. Every time they changed the excise tax and the state sales tax, they changed it to be identical. Now, there's an equalization in this bill, isn't there? Because they removed the exemption, which now makes the excise tax equal to the state sales tax.
Well, equalization may be a good thing. It's a policy of the legislature that they may have been following here, and it may have been a good idea. But equalization or not, the constitutional amendment says if you are raising, there's nothing in it about equalization. If you are raising revenue, as the legislature is entitled to do, here's the procedure they have to follow. And as far as the two-part test goes, that starts with Anderson, and it gets repeated. I'm not sure that I agree that leverage says it's a two-part test. They discuss it together, and they say such a bill. And the question is what such a bill means. I think such a bill, in the context of leverage, means a bill like this one that only incidentally raises revenue. That's always built into the second part of this two-part test. This incidentally comes up in case after case after case. It starts in Anderson, which was the start of this. It has to be a bill to raise taxes. It seems to me that if you read Anderson and think about it and see how it has been raised before, the idea that it needs to be a bill to raise taxes is because in Anderson there was no bill, there was no tax bill at all. And in subsequent cases that have been before this court, the other Fallon case and a couple of other cases, the Calvi versus Dixon, the other Fent case, and in other cases, what's been involved is a bill that didn't affect taxes at all, like a bill that simply authorized bonds, or a bill that took tax money that had already been taken as fees and put it in the general fund, or in the case of Anderson, a bill that simply had the prospect of allowing bounty hunters to track down taxes that were already paid. In these cases, they consistently say that you need a bill, an actual bill that has the effect of raising taxes. And when they say that, make that a two-pronged test, I think the second prong is that it is not enough that a law raise taxes, have the effect of more tax revenue, like a bounty hunter or whatever.
Then what do you make, this is our holding from leverage, and I'm going to read it verbatim. The bill under consideration does not, within its four corners, levy a tax, and for said reason is not per se a revenue bill. That was our holding. Our holding wasn't about purpose in that case. Given that, it's very difficult to understand your argument that we should throw out that second prong, that the bill must levy a tax. We've been deciding these cases for 110 years. I'm not aware of any case where we've done anything but apply that two-part test. That's the test. We've always said that's the test. And so my question is, just assume for the sake of argument that that's the test. Does this bill levy a tax in the strict sense? And if so, how?
Well, if you define levying a tax as other than eliminating an exemption, you've defined the answer to that question. It would. But I think that Fent versus Fallon, which takes a careful look at the whole situation, is not consistent with that. Fent versus Fallon says that if it has the effect that you can have your amendment, but if they have the effect of raising revenue, that it is contrary to what the people have enacted in 1992.
To preserve your time for rebuttal, Mr. Muchmore, thank you.
Thank you, Mr. Chief Justice, and may it please the court. All of the bills challenged before the court today are well within what has previously been upheld in this court's Article 5, Section 33 jurisprudence. In asking you to reject these challenges, we're not asking the court to break new ground, but rather simply adhere to its own precedent. Petitioners, on the other hand, want you to depart from your previous rulings, but principles of stare decisis and the strong presumption of constitutionality require otherwise. The fact that precedent requires judgment in favor of the state in this first case is most clear. This bill does one thing. It alters an existing tax exemption for motor vehicle sales, such that the sales of vehicles are now subject to the same total sales tax as most other personal property, 4.5%. In other words, sales of motor vehicles are no longer given special tax treatment or a special benefit, and will now be shown no favoritism over sales of other tangible personal property. Under this court's precedent for over 100 years, a bill that declares that, quote, certain property theretofore exempt from taxation shall thereafter be subject to taxation is not a revenue bill under Article 5, Section 33. In other words, when a bill removes a tax exemption, that bill does not meet the second prong of the court's Article 5, Section 33 test. It does not levy taxes in the strict sense of the word. In fact, in the specific area of vehicle sales, as this court's already pointed out, this court held that removal of an exemption is not subject to Article 5, Section 33. So there's precedent from this court on almost all fours with this case. And the legislature rightly looked at that precedent and determined that it did not have to go through the special procedures of revenue bills with respect to HB 2433.
Mr. Mazzagani, if that's what they looked at, why didn't they just remove the exemption on motor vehicles completely to get to 4.5%?
Well, the total tax applicable to motor vehicles will now be 4.5%. And I think
why did they go through the gymnastics? Why did they go through the wordplay in order to partially remove part of the exemption, add it and collect it as an excise tax to get to 4.5%, when all they really need to do under your argument under leverage is simply reduce the complete exemption for motor vehicles, and all of a sudden motor vehicles are collected at sales tax to 4.5%, and I would assume would have to be collected by the retailer at the point of sale. Why did they not do that?
Well, the differences in collection, I don't think, are particularly germane to the Article 5, Section 33 analysis. But the legislature certainly had policy discretion to say, well, we're going to partially remove this exemption, but we don't have to remove the whole exemption if we're going to do that. In leverage, they didn't remove the whole exemption. They just modified the exemption to encompass more vehicles than was otherwise before. And I think this case is particularly easy because they didn't remove the whole exemption, and so now the total sales tax is the same as the sales for everything else. If you buy a Hoover or if you buy a Honda, you're going to pay 4.5%.
The problem with this is, I think that's bothering everyone, it sure feels like we're elevating form over function at the end of the day. That the tax is being increased, the taxpayers having to pay more taxes, and Article 5, Section 33 is being evaded because of the form in which that tax was increased. So what about the Constitution should give me some comfort that this form over function argument is okay?
I don't think it's form over function. I think there's a substantive difference between levying a tax and by saying existing taxes will be more equally applicable. So to answer your question in three parts. First, of course, is this court's precedent. With respect specifically to leverage, where this court said that. Second is with respect to this court's general test about levying a tax in the strict sense of the word, that this court was going to take a strict interpretation of that. And third, from a policy rationale, I think the idea is that the Article 5, Section 33 wasn't meant to make it very difficult to remove tax breaks to favored industries. You know, there's a tax credit for buying domestic coal production, and I don't think that it was the intent of Article 5, Section 33 to say that if you give somebody a tax break, when you take it away, we're going to make you go through very onerous procedures to do so.
Well, Mr. Muchmore says that this is the first time sales tax has ever been assessed directly against an automobile. How do you respond to that?
Well, that's absolutely not true. In 1933, when the sales tax was passed first, it was applicable to automobiles. It only became exempted in 1937. So that's just not true. With respect to the two-part test, I mean, this court's precedent makes very clear the two parts of this test. Mr. Muchmore tries to get away with it, and I think that demonstrates how much they want you to reject your own precedent in order to be able to rule in his favor. In this court's cases, it conjoins principal object with levy tax in the strict sense of the word with the word and, not or. It says in the strict sense of the word, which means this court meant that that part of the test has teeth. And in Fent v. Oklahoma Capital Improvement Authority, it calls it a two-pronged test, and then quotes a leverage syllabus saying revenue bills are those laws whose principal object is the raising of revenue and which levy taxes in the strict sense of the word, and said phrase does not cover laws under which revenue may incidentally arise. So that incidental part is just clarifying what the two-pronged test does and does not cover. And this court's other cases, like Board of Commissioners for Lincoln County at paragraph 22, the Court of Civil Appeals at the Walters case at paragraph 7, all reiterate the idea that this is a two-pronged test. And this court held that the levy taxes in a strict sense of the word was part of the definition of revenue bill in the 1991 case of In Re State Question 640, where at footnote 3, In Re Initiative Petition 348, this court quoted the Pure Oil case and says, revenue bills are those bills which levy taxes in the strict sense of the word.
See, under your view of the way this works, and I'm going to give you a hypothetical here that I'm struggling with. Let's say, for instance, the legislature wants a new tax. They know they need 75%. It's a brand new tax. They can't get the votes they need unless they give an exemption to a particular group. That group has some votes who says we will not vote for this unless we get an exemption. So the legislature says we'll give you the exemption. The measure is passed with 76%, a brand new tax with an exemption for a particular group. The legislators then, who couldn't get to 75% originally, turn right around and remove the exemption with 51%. I mean, that would be possible under your view of how exemptions work.
Yes, Your Honor, and that's possible because of this court's precedent making clear that that's the case. So when that group lobbies for that exemption, they lobby for that exemption under the knowledge of this court's precedent, knowing that that exemption can be taken away with the 51 vote. And that's what this court held in Calvi v. Action, as Justice Gersh pointed out, that when the people voted in 1992, they expected this court to follow its own precedent because the definition of revenue bill was not being changed by the 1992 vote. Now, Mr. Muchmore points to the title of the bill saying, well, it relates to revenue and taxation, therefore it must be a revenue bill. But of course, relating to revenue and taxation is not the test. It's does it levy taxes in the strict sense of the word. And so it's not surprising that this court's cases have previously upheld under Article 5, Section 33, measures that had very similar titles. So in Leverage, the title of the bill was An Act Relating to the Motor Vehicle Excise Taxes. In Walters, the title of the bill was An Act Relating to Revenue and Taxation, the same here. In Anderson, the title of the bill was An Act for the Discovery of Property and the Collection of Taxes Thereon. So the fact that the title of the bill, while we agree it's relevant, the fact that it says it relates to revenue and taxation doesn't mean that it's subject to Article 5, Section 33. And the Leverage case is particularly on point because we had the same action here, the modification of an exemption. We had the petitioners, who was a car dealer, like we have petitioners here. Their amici was the Oklahoma Auto Dealers Association, which is also a petitioner here. And the respondent was the Tax Commission, which argued, according to the case, because it does not levy a tax in the strict sense of the word, even though additional revenue could result from the amendment, which is what the Tax Commission admitted in that case.
Don't you agree that that Leverage case was more about closing a loophole than increasing what's collected?
I don't agree with that characterization of the petitioners for two reasons. One, the tax commission in that case, said yes, additional revenue will arise. But two, the reason behind why the court ruled the way it did, it said, okay, here's the two-part test, principal purpose, levy a tax. And then it said, with this bill, it does not within its four corners levy a tax. And then it says, at most, it merely declares that certain property, theretofore exempt from taxation, shall thereafter be subject to taxation. So if you read why the court held what it did, it didn't say that. It didn't hold that way because it said, well, we're trying to remove a loophole that we're not sure exists or not. It said, the reason why we're holding this way is because all it's doing is removing an exemption, and that doesn't constitute a revenue bill. So the reasoning of this
You don't
court's
think going to
decision-
another state to register to sell a car and then make it a used car is not deceptive? That that's not the purpose for this?
It certainly may have been the purpose for why the legislature enacted the bill that was at issue in leverage, but that's not the holding of the court of why the court upheld it. The court upheld it for those words I just quoted, which is, this only removes an exemption. And if we apply that same holding to this case, the case is easily resolved.
It looks to me like a whole lot of parsing's going on. Kind of a rose is a rose is a rose, and if it looks like a duck and quacks like a duck, it's a duck?
Not at all, Your Honor, for the reason that I explained to Justice Wyrick, which was, it was never, Article 5, Section 30 has never been interpreted to say when you take away tax breaks from some favored industry or group of activity, that is the same thing as levying a tax. As a matter of fact, in Johnson v. Grady, what this court said was, for the law providing for the raising of revenue, we must look elsewhere. Therefore, this bill is not the tax levy. And that's the same true here. The tax levy is in Section 1354, which is what levies the sales tax, not 1355, which is what is being amended.
I sure think if you had an individual that bought a car in July and could have bought it in June, and they bought a $20,000 car, they paid $250 more than what they would have paid in June, is going to think that's levying a tax on them.
And that would have been true in leverage too, because if they had bought one of those cars that had been registered in another state, they'd say, hey, now that's more tax that I'm paying. But the fact that they don't get a tax break, as we explained in this brief and as we explained in the Ali v. Fallon case, those constitute a form of government spending through the tax code known as a tax expenditure, which is another reason why this type of thing is not levying a tax, but lowering tax expenditures. Now, of course, to the extent that there is any doubt about the correct interpretation of cases like leverage or whether this levies a tax in the strict sense of the word, that doubt has to be resolved in favor of upholding this bill. The court will only strike down a law if it is clearly, palpably, and plainly unconstitutional. And if it is so beyond a reasonable doubt, that's petitioner's burden. And a reasonable person or legislature reading cases like leverage can and have easily come to the straightforward conclusion that HB 2433 is not subject to Article 5, Section 33. As a matter of fact, almost every time you have somebody who's commentating one way or the other about leverage, they say that leverage stands for the proposition that removing a tax exemption is not subject to Article 5, Section 33. That's what Mr. Ramsey said and what we included in our petitioner's appendix. That's what other courts have said in Oregon and Louisiana, that removing a tax exemption wasn't subject to their version of Article 5, Section 33. Petitioners in the very next case say that. When they quote leverage, they put a parenthetical saying removal of a tax exemption is not subject to Article 5, Section 33. So I think any reasonable reading of cases like leverage and this court's precedent as a whole, which is it's not just about leverage. It's about that phrase, what do we mean when we say levy a tax in the strict sense of the word? Because Mr. Muchmore says, well, it indirectly, has the effect of a tax and therefore it's a tax, but that doesn't sound at all like levy a tax in the strict sense of the word. As a matter of fact, indirect effect of a tax, exactly what this court rejected in Anderson by saying, no, it has to have the direct and avowed purpose of levying a tax. Which, sort of goes to another point counsel on the other side makes about quoting Fent v. Fallon. He quotes the portions of Fent v. Fallon that are talking about Anderson and how Anderson may have countenance lowering of revenue as being a revenue-raising bill because
As a matter of fact, we overruled part of that, didn't we?
that was going to exactly be my point. He was quoting the parts that this court then later said, let us make very clear that that dicta in Anderson about just because you're collecting a tax, even though you're collecting less of it, it's a revenue bill, the court overruled that part of Anderson to the extent that that part was ever the law. I think it was probably dicta, and this court made clear that to the extent that it was dicta, it was overruling it. I don't want to belabor the points that we made in our brief, so if this court does not have any further questions, I'll yield the rest of my time.
In this case, they are trying to put a whole lot more on leverage than that case will support. And this case reflects that. And where leverage would take us if they accept it the way they have said it is a whole lot farther than that. Let's look at that for a moment. They are arguing for an absolute rule that if it removes an exemption, it cannot be a tax. Never mind that they did indirectly what they couldn't do directly here.
But the exemption, the tax was already in place and there was an exemption in place. There's no new sales tax in Oklahoma. It was that certain items were exempt from that portion of the sales tax. So it still seems to me there's a fundamental difference in taking away something the legislature lawfully and constitutionally granted to a special interest. And that's not what we're talking about. You mentioned the idea of going to Texas to try to avoid the tax in Oklahoma. I mean, this is a special interest. Exemptions are special interests. Isn't there something about that that's repugnant in the Constitution? I think there is. The Constitution is very strict on exemptions. But it was not amended procedurally like Article 5, Section 33. Why didn't they amend Section 50 at the same time?
Well, I assume that it did not occur to them that when they passed a law that said that bills raising revenue would have to be go through the election or the supermajority, and they said in that case, and they said in Fallon, that rather than read this like a lawyer and parse it, that you take it as a reasonable individual would have understood what it meant. And what it meant is you cannot raise taxes, you cannot have a bill raising revenue without going through this. And
is it your position that the 1992 amendment changed the definition of revenue bill? Because we've rejected that twice in very recent cases.
No, it didn't change the definition of revenue bill, but I don't agree that that's been rejected. The idea that an exemption cannot be a revenue bill does not have support in the cases. And getting back to leverage, the leverage was passed in the day, which I remember, that the law of a case was to be stated in the syllabus by the court. And in that syllabus by the court, they said revenue bills are those laws whose principal object is the raising of revenue, and which levy taxes in the strict sense of the word, and such phrase does not cover laws under which revenue may incidentally arise. That fit the facts in that case. It's pretty incidental when you remove what I think can fairly be called a loophole on car dealers doing what they did. The idea here and the court then in the second part of the syllabus described what this did, redefined what an automobile is, and said that such bill is not which only incidentally creates revenue, is not. And the question is, what do they mean by such bill? I think such bill meant what we have in front of us is not a bill that raised revenue.
And I agree with you that leverage, we don't have a lot of cases like leverage, cases dealing with the exemptions, and that's why I went to look further to try to make sense of leverage. And that led me to our Constitution. And I want to get your response to that, because we have a line of cases, very early cases, and an unbroken line of cases where we said that the legislature is vested with power under Article 6, Section 10 of the Constitution to, quote, disqualify, curtail, or annul any tax exemption.
Well,
Okay? And we have an unbroken line of cases where we've said that we strictly construe statutory tax exemptions because they're disfavored. And so, I mean, was leverage just acknowledging that fact that's baked into our Constitution, that we don't like exemptions from taxes? They're
leverage
disfavored.
did not involve removing an exemption. Leverage involved defining what was covered by it, and doesn't come under the heading of a bill that removed an exemption. Of course, the power is in the legislature to pass exemptions, and they may be favored and they may not. But the language that I quoted in the bill, in the case that enacted this amendment, and in Fent versus Fallon that talked about it, if you read those cases, the message is clear. The people's power to dictate how the legislature will do all these things that they have the right and duty to do has hereby been reserved, and it really means it. It means that if it has the purpose and effect of raising revenue, that this business about this rule that we strictly construe, that we presume constitutionality. You cannot read those cases, both of them, one of them in 2014, and come away thinking that anything except that this amendment means what it says, means what it would be understood to be said, and is not to be subject. And it addressed amendments. It says if it's an amendment, yes, you can do it, but only if it doesn't have the fact of raising revenue. I mean, they could have that really takes you a long ways here. Even if they simply removed the entire 4.5%, that would raise maybe $500 million, and they could do it, and the argument would be made with a straight face. It is removing an exemption. It is removing the entirety of the exemption, and therefore it's proper. But you can go further than that. The exemptions and deductions and the like that are inherent, according to the Tax Commission, which went through, I didn't know they did this, but they went through and compiled a list of all the exemptions, deductions, and the like, and they came up with billions and billions of dollars. For example, the sales tax, there's a sales tax exemption.
Mr. Muchmore, that's not in front of us. I think you're confusing the issue. We're dealing specifically with an exemption on an automobile sale. We have a case on point in Oklahoma. You don't think the legislature has the power to remove an exemption unless they're subject to the amendment that deals with raising taxes. You're ignoring the levy of tax. Why don't you explain how this is a levy of tax?
It's a levy of tax because in practical effect, it is identical in practical effect to if they had simply raised the excise tax on automobiles, and by imposing a tax, impose and levy are used interchangeably. When you are imposing a tax, when you put that tax into effect and people have to pay it, and they didn't yesterday. That's what a reading of Fent versus Fallon and of the constitutional amendment cases say. They say that imposing a tax, imposing for additional revenue, which is done by a statute, is raising revenue, and
But
it should be read that way.
people pay more fees all the time. The court filing fee, as you know, has gone up over the years. I mean, just because someone pays more doesn't mean that that's a levy of tax. I think you're parsing words.
Well, it is literally true that just because you pay more, it is not tax. The court has looked at laws to see whether they are for the purpose of raising. They look at the purpose of raising revenue, or the purpose of, in the case of fees, of the right to engage in some activity or be in court or a large number of things. They have made that distinction. That doesn't apply here. There is no case, and they've cited none, where a broad law was passed that had anything like the dimension that this one does. And again, getting back to leverage, it was a minor fix, and the court's language is consistent with that. There is no case comparable to this where this kind of thing was done. To say that, I mean, they are arguing, and they have to argue, that an exemption here has to be automatic, and that would cover raising it not to 1.25%, but raising it to 4.5%. It would cover there is a sales tax exemption, stated as an exemption and listed by the Oklahoma Tax Commission, for a sale from a wholesaler to a retailer. That is absolutely written as an exemption to the sales tax like this. If that exemption were removed for equality with other sales, that would raise like $2.7 billion in taxes and another billion in use taxes. They are arguing here absolutely that a exemption is automatically fair game and can be done without this. That flies absolutely in the face of what this court has twice said about that law. I have not heard an answer to what if we remove the sales tax on the exemption on sales from wholesalers to retailers, and it raised billions of dollars. The answer, according to what the argument the government is making, would be that would be all right because it is an exemption.
So your view is that
excuse me.
is that in 1992 the people articulated a policy in favor of special exemptions from taxation. They wanted to make it harder to remove special exemptions from taxation. That's the state's policy.
They adopted a policy that whatever you call it, however you attempt to do it, if it results in a tax being levied that wasn't levied before, it's raising revenue, and it's not to be parsed, it's not to be excused. It is the power of the people has been exercised. The power of the legislature is there. The procedure they have to follow is changed.
Justice Reeve.
Mr. Muchmore, I understand the concept of exemption to be legislative grace, that they have withdrawn the burden of taxation from property. How is it, do you understand an exemption to be the same thing, or what is your definition of an exemption?
Well, an exemption is simply a law that a law that says that another law that imposes a tax will not apply in certain circumstances, and they may be considered the grace and the power of the legislature, and that power is still there, of course, if it's done right. But that's a lot of grace if you look at the fact that the Tax Commission says that exemptions, deductions, and the like amount to $10 billion.
But if they extend the grace, can't they withdraw it as well?
Absolutely, they have the power to do that as long as they follow the procedure mandated by the people in the amendment to the Constitution.
I'm having trouble connecting exemptions to Article 5, Section 33, Mr. Muchmore. That's my problem. I see an exemption as an entirely different creature, and the legislature had the power to give it, and they had the power to take it away. That's separate from their taxing power.
Well, as I indicated, if that's true, then we're looking at a potential $10 billion of additional taxes without following this law, and that cannot have been the intention. It is, again, it is not a matter of legislative power. They have it. But if that power is extended so that a tax, here a sales tax, that wasn't imposed before and hasn't been apparently for 80 years, it is doing what the original case and the Fallon case both said. It is imposing a levy. It is imposing a tax. They have the power to do it. The people have reserved the right to have it done in a way that follows the procedures that are dictated.
Thank you.
Thank you, Mr. Muchmore. This case will stand submitted. We've got 10 minutes till the next argument. The court will be in recess until 10 o'clock.